Senior counsel Andrea Johnson has submitted to the Supreme Court of Appeal in Bloemfontein that the Pretoria High Court Judge, Thokozile Masipa, elevated Oscar Pistorius and absolved him of his crime. The National Prosecuting Authority has approached the SCA to have the disgraced Paralympian 6-year murder sentence increased. The state is arguing that the sentence is too lenient considering the brutality of the crime. The state succeeded in its previous bid to have the initial culpable homicide conviction overturned to a conviction of murder. Pistorius shot and killed his girlfriend, Reeva Steenkamp, on Valentine's Day in 2013.
She erred in the following aspects. When the court of quo sentenced the respondent in the matter, the court ignored, in our submission, key material findings of this court's judgment when this court found the respondent guilty of murder dolus eventualis. And in so doing, we said that some of the aspects is that the court firstly regarded the respondent's belief that there was an intruder in the house as a mitigating factor. And this is found in this honorable court's judgment at paragraph 53. And in rejecting the respondent's version of putative private defense, that when the respondent testified at trial, he stated that he had not intended to shoot the person whom he felt was an intruder, and further that his evidence is so contradictory that one does just not know his true explanation for firing the weapon. Secondly, the court of quo regarded the respondent's purported or alleged feelings of vulnerability and anxiety.
But the current therapy, she deals with that in her judgment. Look at page 4023. She acknowledges the circumstances in this matter have changed, as the accused has now been found guilty of murder dolus eventualis, which is a more serious offense than culpable homicide. She deals with that.
It is so. I'm not saying, Justice Basiello, that she did not consider the judgment of this court at all. Our argument is simply this, that in certain aspects...
I asked a question. In her judgment that we have to take on appeal, where did she err?
And that's
maybe just to follow up on Justice Basiello's question. I look at the judgment, and Judge Masipa seems to talk about remorse. Are you in a position to address us on that?
As the court pleases. With regards the aspect of remorse, we found that the court of quo found that the respondent had genuine remorse. However, it is clear from this honorable court's judgment that an essential ingredient for genuine remorse is missing, namely a reason from the respondent for firing the 4 fatal shots. On 3 pertinent occasions, this honorable court, in its appeal judgment at paragraph 17, 49, and 53.
What did Mr. Pistorius do to try and show remorse?
As the court pleases, he said, I am sorry.
He made various attempts to talk to the family. He apologized in publicly in court.
As the court pleases.
The Steenkamps admit he tried to talk to them and they refused to talk to him. What more could he have done?
It is so. One does not say he is not saying that he is sorry, but one cannot elevate his regret and his sympathy to that of remorse. The test for remorse...
Is it not a semantic, or leading us into a semantic quagmire? The man stands in open because I apologize. I did something very horrible. He tries to communicate with the family. How do you verbalize your remorse?
Taking the court into his confidence
and
saying...
He did. He apologized before the trial started in court. He did.
As a court pleases.
It's there on record.
My submission in that regard, Justice Basiello, is simply that in so doing, yes, there is those verbal apologies, but without more, that is not genuine remorse.
What more? What more should he have done? I'm interested. What more should he have done?
For me, he should have taken the court into his confidence, and even if he didn't, when he had the opportunity in his consultations with Professor Scholes, what he could and ought to have done was said, okay, the court has found me guilty of murder.
The evidence because it's on record?
As a court pleases, it's simply but to say that in so doing, he should have taken the confidence of the court and said, this is why I did it. That is what we want him to say. This is why I did it. Because with nothing more, Judge Sariti, then there is no true, genuine, gut-wrenching remorse.